Hello everyone, I am Ginelle Libanan, together with Adrian Ralph Hilado and Christine Noxon. We will tackle about Chapter 6, Recessible Contracts, on our subject, Law on Obligations and Contracts.
In Article 1380, contracts validly agreed upon may be rescinded in the case established by law. First, we will know the meaning of recessible contracts. Recessible contracts are those validly agreed upon because all essential elements exist and therefore legally effective. But in the case established by law, the remedy of recession is granted in the interest of equity.
Binding force of recessible contracts. They are valid and enforceable, although subject to recession by the court when there is damage or prejudice to one of the parties or to a third person. In a recessible contract, there is no defect at all, but by reason of some external facts, its enforcement would cause injustice. While meaning of recession is an equitable remedy granted by law to the contracting parties and sometimes even to a third person in order to secure reparation of damages caused by them by a valid contract by means of restoration of things to their condition prior to the celebration of said contract. The following are requisites in order that the remedy of recession under this chapter may be availed of. The contract must be validly agreed upon. There must be lesion or pecuniary prejudice or damage to one of the parties or to a third person. The recession must be based upon a case specially provided by law. There must be no other legal remedy to obtain reparation for the damage. The party asking for recession must be able to return what is obliged to restore by reason of the contract. The object of the contract must not legally be in the possession of third person who did not act in bad faith, and the period for filing the action for recession must not have prescribed. Now let's go to Article 1381. The following contracts are recessible. First, those which are entered into by guardians, whenever the wards whom they represent suffer lesion by more than one-fourth of the value of the things which are the object thereof. A ward is a person under guardianship by reason of some incapacity. For example, Jane is the guardian of Will. Jane sells the property of Will worth 20,000 pesos for only 15,000. The contract of sale cannot be rescinded because the lesion is not more than one-fourth. However, if the property is sold for less than 15,000, Will can rescind the sale of property for proper action in court upon reaching the age of maturity. Second, those agreed upon in representation of absentees, if the latter suffer the lesion stated in preceding number. An absentee is a person who disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property. A court may appoint a person to represent him, specifying his powers and obligations in accordance with the rules concerning guardians. Likewise, the absentee must suffer lesion by more than one-fourth of the value of property object of the contract to entitle him to the remedy of recession. Third, those undertaken in fraud of creditors, when the latter cannot in any manner collect the claims due them. The action to resign in fraud of creditors is known as action Paulania. The following requisites must be also be present. First, there must be existing credit prior to the contract to be rescinded, although it is not yet due or demandable later. Second, the subsequent contract made by the debtor conveys a patrimonial benefits to a third person. Third, there must be a fraud on the part of the debtor which may be presumed or proved. And the last one, the creditor, has no other legal remedy to satisfy his claim, that is cannot recover his credit in any other manner. It is being required to the debtor be insolvent. Fourth, those which refer to things under litigation. if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. In number 3, the purpose of the remedy is to secure the payment of the existing credit of a third person against the party to a contract suit to be rescinded. Here, the purpose is to make effective the claim of the party litigant over a thing under litigation, which was the object of the contract entered into by either party with another person. The right to file an action for rescission arises in favor of the plaintiff when the defendant enters into a contract over a thing in litigation without knowledge of or approval of the plaintiff in the court. Fifth, and the last one, all other contracts specially declared by law to be subject to rescission. Some of the specific contracts subject to rescission are as follows. Article 1098. A partition, judicial or extrajudicial, may also be rescinded on account of lesion when any of the co-heirs receive things at value less by at least one-fourth than the share of which he is entitled considering the value of the things at the time they were judicial. Article 1470 Gross Inadequacy of Price. Article 1659 if the lesion or less should be complied with the obligations set for the Articles 1654 referring to the obligations of the lessor and 1657 referring to the obligations of the lessee. Under Article 1539, the vendee may exercise the remedy of rescission. Also under 1599, where there are breach of warranty by the seller and the buyer at his election. Now let's go to Article 1382, payments made in state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were affected are also recessible. Payments made in state of insolvency. The present article speaks of payments, not exactly of the contract. A debtor is insolvent if he does not have sufficient properties to meet his obligations. It is not necessary that the debtor's insolvency be judicially declared. Under this article, the payment must have been made for obligations to whose fulfillment the debtor could not be compelled at the time they were effected. Such payments are also recessible. Included in the obligations referred to are not only those that have not yet become due and demandable, obligations with a suspensive period or condition, but also those which cannot legally be demanded, such as natural obligations, and those that have prescribed. Now let's go to Article 1383. The action for recession is subsidiary. It cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same time. Recession of contracts under Article 1383 should be distinguished from recession of reciprocal obligations under Article 1191, although both presuppose contract validly entered into the subsisting and both require mutual institution with proper they are not entirely identical. Recession under Article 1383 is not principal remedy. It is only subsidiary and cannot be availed of only injured parties. Proves that he has no other legal means, aside from the signing of the contract, to obtain satisfaction for his claim or redress for the damage caused. If the damage repaired, as in the case of lesion suffered by the ward, recession cannot be take place. A recession contract must be assailed directly only by proper action in court, and not directly or collaterally by way of defense. An independent action is necessary to prove, and a contract is recessible. It may not be raised or set up in summary proceeding through a motion. The next article, or Article 1384, will be reported by Christine Hodgson.